I expressly do not consent to this court's jurisdiction and do not.
Well, then
Any rights.
you are not a named party. So if you're not consenting to this court's jurisdiction, sit down.
Oh,
You can go.
oh, I see. So I need to,
I don't know what you need to do, but
well, let me respond.
to what? You're not consenting to the jurisdiction of this court. Why am I hearing from you?
I'm recanting
You're recanting what?
what I just stated.
Which part?
The part that I lost my spot. Oh,
Well, no, it doesn't work that way.
okay, I'm not really understanding, but I am nervous, quite nervous.
This entitled sovereign citizen squatter Karen is back in court, this time over an alleged fraud case tied to $1 million house she flat out refuses to leave right out of the gate. The plaintiff's attorney breaks it all down. And honestly, you'll want to pay attention, because it exposes just how ridiculous her scheme really is. She's running the classic sovereign citizen playbook, spitting out word salad about rights and ownership. But on paper, this has got to be one of the sloppiest fraud cases I've ever seen. What kills me is the confidence. She struts into the courtroom like she owns the place. Meanwhile, the actual evidence is screaming otherwise. Here's the wild part. Squatters really do get certain legal protections in some states. That's why people like her try to exploit loopholes. But let's be real. This isn't just squatting. This is straight up fraud, wrapped in sovereign citizen nonsense. So, I want to know what you guys think. Should squatters have rights? Or should laws be tightened up so cases like this never even make it this far? Let's dive in and watch this disaster unfold.
Ian Redmond, P70599, on behalf of the plaintiff.
And your name, ma'am?
Yoshia Banks occupant.
Pardon?
Yoshia Banks occupant.
Doshia Banks occupant, Your Honor.
Okay. So you're not Miss Whitlow?
No.
So what is your position in this case as you see it?
If I may, Your Honor.
Okay, good. Go ahead.
Ms. Banks claims to be an occupant of the property. She filed a bankruptcy case listing the property as hers. The bankruptcy stay was lifted, which gave rise to our motion to reopen the case. The order lifting stay I would like to present to the court because it has some interesting language in it, Your Honor, which includes, it is further ordered that the bankruptcy court finding this filing of this petition was part of a scheme to delay, hinder, and defraud VMC REO LLC. Additionally, Your Honor, the bankruptcy court ordered, notwithstanding Rule 4001A3, a bankruptcy rule,
Right.
creditor VMC REO LLC may execute on its order immediately. The order shall be binding and effective despite any conversion of this bankruptcy case to a case under any other chapter of Title 11 of the United States Bankruptcy Code. Further, that the recording with the appropriate governmental entity of this order shall constitute a bar to refiling any case under any chapter of Title 11 of the United States Code as to the property located at 5779 Pinecrest Estates Drive, Ann Arbor, Michigan, the property in this case. A debtor in subsequent case under this title may move from relief from this order based upon a change of circumstances or for good cause shown after notice and hearing. Said bar shall be for 2 years from the entry of this order or until such time creditor relinquishes their rights to the property. This order came out June 24th of this year. I have a copy for you. I will note, Your Honor, that Ms. Banks has filed an appeal of that order in the federal Eastern District of Michigan. That appeal is pending, but the status quo as of right now is that there is no stay, and that order lifting stay holds until such time as the appellate court does something. Additionally, Your Honor, there is no stay from the appellate court. They have not issued a stay, and in fact, it would be appropriate that there would be a bond placed or an escrow order of some sort, because BMC has been the owner of this property for the past year and does not have access to it. Additionally, Your Honor,
There's more. Go ahead.
there's a lot going on.
Yeah.
Additionally, Your Honor, Ms. Whitlow, who, as far as I know, actually exists, but I don't have any evidence to that effect, has not appeared in any hearings in this court, did not appear for her deposition that she was noticed for in the federal case, and in a federal case, the federal court issued a show cause order to Ms. Whitlow that she had to present certain documents from this court, which she failed to do. Her deadline to do so was, I believe, July 3rd. Let me confirm that. Oh no, July 10th. And she did not supply any of those documents. I can present that show cause order if you would like.
I don't know that I need that because I'm not.
The reason that I mention all of this, Your Honor,
Go ahead.
is that this is $1 million house in Ann Arbor that Ms. Whitlow purchased with a mortgage and less than a year later defaulted. The foreclosure went through, the sale occurred, the redemption period expired, and we came forward to evict. Since then, there have been multiple bankruptcies. Ms. Whitlow filed 2 different bankruptcy cases. A young man who apparently lives in Arizona filed a bankruptcy case and listed this property as his residence. Ms. Banks has filed a bankruptcy case and listed the property as her residence. It should also be noted that Ms. Banks was a bankruptcy preparer and has been forbidden from the bankruptcy court from preparing bankruptcies for anyone other than herself.
And I'm just guessing here, but it looks like she pretended to be the Whitlows, grabbed a mortgage on $1 million home, defaulted, and then tried to play the bankruptcy card to keep the house, as if she had any legal claim. The catch? She's not even on the mortgage. That's like borrowing your neighbor's car, crashing it, and then filing the insurance claim in their name. 0 cents. What blows my mind is how she thought she could pull this off without leaving a paper trail. Mortgages and bankruptcies leave records stacked a mile high. The second investigators start connecting dots. The fraud glows like a neon sign. Judges don't get swayed by sovereign citizen buzzwords or word salad. They ask one question: did you have a legal right in the first place? And here, she's got nothing. Instead, she just piles lie on top of lie, thinking she can bury the system under nonsense paperwork. But this isn't just some quirky civil dispute, it's textbook fraud. And if she keeps pushing this, prison is definitely on the table. So what do you think? Does she even realize how bad this looks? Or is she so deep in the sovereign citizen fantasy world that she just doesn't care anymore?
I list all of these things to show that the scheme continues. And that's why we would like to reopen this case, because there is no stay in place. We would like to move forward with an immediate eviction, at most an 11-day vacate. And if for some reason that would not be amenable to the court, we would ask for an escrow order or a bond. On $1 million property, I think it would be reasonable that $10,000 a month rent would be reasonable.
All right. Thank you. Ma'am,
Yes, Your Honor?
what do you want to tell the court?
Well, just for 60 seconds, and then I wrote something up because I am nervous, quite nervous. But I, Doshia Banks, is respectfully appear, specially and conditionally, for the sole purpose of protecting federally vested occupancy rights and opposing unlawful state action. I expressly do not consent to this court's jurisdiction and do not.
Well, then you are not a named party. So if you're not consenting to this court's jurisdiction, sit down.
Oh,
You can go because you're not a named party.
I have a lease.
You are not a named party on this. You may have a lease with someone else, and
No,
then
I have
you
a
can
lease.
go challenge it. With who?
With Whitlow. Ms.
Then
Whitlow,
you need to go against Miss Whitlow.
Pardon me?
Then you may need to go against Miss Whitlow. But if you're not consenting to the jurisdiction of this court, you might as well just sit down. You are not a named party. I do not have to hear from you.
Oh, I see. So I need to,
I don't know what you need to do, but
well, let me respond.
to what? You're not consenting to the jurisdiction of this court. Why am I hearing from you?
I'm recanting
You're recanting what?
what I just stated.
Which part?
The part that I stated that I'm not. Oh, I lost my spot. Not consenting to this court's jurisdiction. So I'm going to recant that
So you are consenting to this court's jurisdiction?
at this moment.
Well, no, it doesn't work that way. You don't get to say, well, now it's okay, and then not later say no.
Okay.
You know what? Here's the problem. You've not filed anything with this court. So I don't know why, on those grounds, why I'm hearing from you.
Okay. If I may, I do have time, I do believe, to go file an answer and counterclaim. I was just led under false
Answer and
pretenses
counterclaim to what?
to their complaint for eviction.
You have a lease with, allegedly, with Miss Whitman.
Correct.
Then that is who you need to pursue it against,
Okay. And
or whatever the heck you're doing.
well,
Because you don't have, there is no privity of contract to the extent there would be, or relationship as between the plaintiff in this case and you.
okay, I'm not really understanding, but
What she's pulling here is one of the oldest scams in the bankruptcy fraud playbook. And honestly, I don't know how she thinks this isn't see-through. Filing for bankruptcy triggers something called an automatic stay. That's basically a freeze on debt collection until the court sorts it out. No eviction, no repossession, no garnishments. And scammers love it because it buys them a couple weeks of breathing room. The problem? Judges see this trick every single day. And when they catch on, it backfires. Hard, sure, she might have bought herself a short delay. But the risk? We're talking years behind bars for fraud. That's not strategy, that's pure desperation. Bankruptcy isn't a magic reset button. It doesn't erase lies. It just delays the inevitable. And in her case, it makes things 10 times worse. So what do you think? Does she actually believe this would work? Or is she just so far gone she'll try literally anything at this point?